Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
My name is Leah Richardson, and I'm a partner in the K&L Gates Research Triangle Park office. My practice focuses on healthcare regulatory and transactional matters, including a particular focus on the 340B drug pricing program and other pharmacy-related matters.
And I'm Victoria Hamscho. I'm an associate in the firm's Washington, D.C. office, where my practice focuses on healthcare policy and regulatory matters. In this episode of Triage, we will provide an update on next month's Supreme Court oral arguments in Rutledge v. Pharmaceutical Care Management Association, a case which could significantly impact state regulation of pharmacy benefit managers, or PBMs, including various state laws prohibiting PBMs from engaging in two-tier 340B pricing models.
Thanks, Victoria. By way of background, back in January, the Supreme Court accepted Arkansas's request to take up Rutledge v. Pharmaceutical Care Management Association. The case was originally scheduled to be argued on April 27th, but was rescheduled due to the COVID-19 pandemic to October 6th. At issue here is a 2015 amendment to an Arkansas statute, Arkansas Code 17-92-507, aimed at lowering drug prices by regulating the rates at which PBMs reimburse pharmacies for drugs and giving pharmacies a right to appeal a PBM's reimbursement rate. The brief history of this case is that a few months after the amendment went into effect, the Pharmaceutical Care Management Association, or PCMA, which is a trade group representing the interests of PBMs, filed suit in the Eastern District of Arkansas, claiming the provisions were preempted by Medicare Part D and ERISA, among other constitutional claims. The district court held that the Arkansas statute was preempted by ERISA, but rejected the Part D preemption, as well as PCMA's other claims. PCMA appealed the Part D preemption holding, and Arkansas cross-appealed the district court's holding that the statute was preempted by ERISA. The U.S. Court of Appeals for the Eighth Circuit struck down the law in 2018, holding that the Arkansas law was preempted by both Part D and ERISA. The Supreme Court appeal is focused only on the ERISA preemption issue. As you may know, ERISA preempts any and all state laws insofar as they may now or hereafter relate to any employee benefit plan. This language is quite broad, and multiple circuit courts, as well as the Supreme Court, have considered over the last few decades how broad this preemption provision should be interpreted. In this case, the Eighth Circuit held that the Arkansas statute was preempted by ERISA because it relates to and has a connection with employee benefit plans. The Eighth Circuit found that it was bound by its reasoning in an earlier case, PCMA v. Gerhardt, where the court held that a similar statute made an implicit reference to ERISA through regulation of PBMs who administer benefits for covered entities, which by definition includes entities that are necessarily subject to ERISA regulation.
In its petition, Arkansas highlighted the Supreme Court precedent establishing that a state law implicitly refers to ERISA if it acts immediately and exclusively upon ERISA plans, or the existence of ERISA plans is essential to the law's operation. Arkansas argued that if a law like the one at issue regulates a class of TPAs or third-party administrators or claim processors whose customers merely include ERISA plans, it would logically follow that the law was not acting immediately and exclusively upon ERISA plans, and that the existence of ERISA plans was not essential to the law's operation. Solicitor General Noel Francisco and the Attorney Generals from 31 states in the District of Columbia argued that the Supreme Court should take up the case, in part because the plans that the PBMs administer or manage need not necessarily be ERISA plans in order for the PBM to be subject to the statute's requirements. And as such, the Arkansas law was not acting immediately and exclusively upon ERISA plans.
The Supreme Court's decision in Rutledge could have a significant impact on nearly 40 state laws that currently regulate the conduct of PBMs. Groups like the National Community Pharmacists Association have argued that PBMs behave like monopolies and fail to manage the cost of drugs, inflating prices for patients and destroying local pharmacies that cannot afford the decreased reimbursement that PBMs often force on pharmacies so that PBMs can benefit from the spread between the reimbursement provided to those pharmacies and the price PBMs charge health plans. PCMA, meanwhile, has continued to zealously file many lawsuits arguing that these state laws are preempted by federal law, including ERISA. In fact, just last month, in PCMA v. Mylan Tuft, the Eighth Circuit again struck down a similar 2017 North Dakota law limiting the fees PBMs can charge pharmacies, holding that the law is preempted by ERISA on similar grounds to its decisions in Gerhardt and Rutledge.
The Supreme Court decision in Rutledge could also have a significant impact on a number of state laws prohibiting PBMs from paying lower reimbursement, charging additional fees, or limiting network access on the basis of participation in the 340B drug pricing program. This practice gained visibility at the national level when CVS Caremark, one of the largest PBMs in the country, alerted 340B covered entities in late 2018 of amendments to its payment policy that would reduce reimbursement to their pharmacies. While CVS Caremark had decided by February 2019 to not go through with the amendments, the controversy shed light on the practices of some PBMs. The Health Resources and Service Administration, or HRSA, has acknowledged the practice of discriminatory pricing, encouraging the covered entity to reach out to the payer to craft an alternative business solution that permits each of the parties to fulfill their goals. HRSA has generally taken the position that there's no statutory provision in the 340B statute prohibiting a payer from reimbursing a 340B covered entity at a level that may be different than a non-340B entity.
So just in the past 2 years, at least 9 states have responded to this issue by enacting legislation prohibiting PBMs from setting lower reimbursement rates for drugs provided to 340B covered entities, including Oregon, Minnesota, South Dakota, West Virginia, Montana, Massachusetts, Rhode Island, Oregon, and Utah. And states like Ohio, Florida, Georgia, and Tennessee are also considering similar legislation. So as covered entities continue to engage with state policymakers, arguing that discriminatory pricing violates the intent of the 340B program, the Supreme Court's decision in Rutledge could potentially limit the ability of states to regulate this practice. So the Supreme Court's decision in Rutledge will have a significant impact on these 40 state laws regulating PBMs, and more specifically on the number of state laws prohibiting PBMs from engaging in this 340B discriminatory pricing. Stakeholders, including pharmacies and 340B program covered entities, should carefully consider the potential impact of these developments. Our healthcare and FDA practice regularly advises stakeholders on 340B program and other pharmacy matters and is able to assist in this regard. Thank you so much for listening to this episode of Triage on the impact of Rutledge. Please don't hesitate to contact us if you have any questions.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.